Mr. Speaker, I beg to present for second reading a bill shortly entitled Proceeds of Crime Amendment. Mr. Speaker, this bill again is part of our international obligations through the Financial Action Task Force, Mr. Speaker. And this one we did with recommendation number 4. And Mr. Speaker, we are called to make all these commitments. We are called to follow all these procedures, Mr. Speaker. And this has a heavy administrative cost and administrative burden on us, Mr. Speaker. And the sad thing is that we have to deal with all these laws, deal with all these changes, deal with all this monitoring, Mr. Speaker, and our forms of income are being limited, and they are being shortened, and they are being taken away from us liquor by liquor, Mr. Speaker. It's a crying shame, Mr. that small islands like us have to follow these international obligations, Mr. Speaker. We have to. We almost have no choice. We have to pay high price people to assist us, Mr. Speaker, to meet these international obligations, Mr. Speaker. And most importantly, the people who are under the most scrutiny are politicians. We are the ones who are called PEPs. We are the ones who go through the most scrutiny. Mr. Speaker, imagine I was asked by a bank to show my proof of income. So I was asked by the bank to send my salary statement. So I said to the bank that my salary is in the estimates of expenditure. It's no secret my salary is in estimates of expenditure, Mr. Speaker. But these are kind of things, Mr. Speaker, that we have to go through. But sometimes I wonder, Mr. Speaker, that do the people who ask us to impose these things, do they impose it on themselves? But, Mr. Speaker, we have no choice. We have no choice. We have to do it. And we have to spend the money and the resources necessary to do it, Mr. Speaker. So this one was the previous one on United Nations. This one is recommendation number 4, which relates to confiscation and provisional measures, and recommendation number 43 relating to powers of law enforcement and investigative authorities, Mr. Speaker. In a nutshell, Mr. Speaker, what it does is it amends the previous Proceeds of Crime Act, which we passed in this Parliament, to strengthen it, Mr. Speaker. To strengthen it, Mr. Speaker. Because under the Proceeds of Crime Act, Mr. Speaker, which is Act 3.04 of the revised laws of St. Lucia, the Crown is permitted to confiscate or forfeit the physical assets, land, vehicles, and cash of persons convicted of criminal offences, where said physical assets are tainted by the criminal conduct, Mr. Speaker. That exists already under the Proceeds of Crime Act. But, Mr. Speaker, on January 25, 2021, St. Lucia's 4th round mutual evaluation report was published, again on the FAFT website, and highlighted that St. Lucia was deficient. Even though we passed that bill, we were still deficient in complying with the above-mentioned recommendations. On becoming aware of the shortfalls in the Act, the National Anti-Money Laundering Oversight Committee, NAMLOC, worked assiduously to propose the changes to the Act that would be required. And the Attorney General, Mr. Speaker, and his staff have been constantly asking us, telling us about NAMLOC. In our ears every day is NAMLOC, Mr. Speaker. So we have to do what NAMLOC says. Mr. Speaker, but you already pay when you're small. Mr. Speaker, St. Lucia is expected as part of its follow-up process to apply for re-rating. We are rated already, and we have to be re-rated in November 2023 at the plenary of the FATF on the 40 recommendations that rated as non-compliant and partially compliant is his mutual evaluation report, Mr. Speaker. The Proceeds of Crime Act has been identified as one of the key enactments in need of amendments for the purposes of re-rating. So the original Proceeds of Crime Act was not good enough. So you have to go back in there and you have to do some amendments which are outlined in this bill, Mr. Speaker, to make us compliant with the MER report, Mr. Speaker. Mr. Speaker, I'm sure that when we do that, sooner or later, we'll be back for another amendment, Mr. Speaker. And I'm certain, Mr. Speaker, that will happen. But, as they say in Patois, Lucia va vet devant poule. We have no choice, and the banker will tell you, we have no choice. Because Mr. Speaker, that's important. Because banks are now under pressure for the corresponding banking facilities, Mr. Speaker, under a lot of pressure. And certain islands in the region, in CARICOM, they've suffered. One particular island, Mr. Speaker, all the corresponding relations were taken away from them. And Mr. Speaker, I don't think, when we play politics in these things, I don't think we have explained to the public sufficiently what losing corresponding banking facilities means, Mr. Speaker. It means that your credit card is useless. It means that buying things on the internet is useless. It means that you can make no transactions with plastic because the bank has nowhere to clear it when you make the transaction, Mr. Speaker. And certain islands in the region have suffered from that punishment. So we have to enact that legislation. We have to enact it, Mr. Speaker, because all this is in one big soup. Corresponding banking, mutual evaluation reports, recommendations of the FATF, all of them are in one soup, Mr. Speaker, to ensure that small islands are compliant, Mr. Speaker. So, Mr. Speaker, the Asset Recovery Unit of the Regional Security System RSS, not those are here, not those that are here, not the soldiers, is what is called the Asset Unit of the Regional Security System, Mr. Speaker, Asset Recovery Unit. And they provided a draft Proceeds of Crime Bill for member countries to review and consider in an effort to assist member countries in the development and strengthening of their respective anti-money laundering, terrorist financing legislative frameworks. The bill makes provision inter alia for civil asset recovery, which will be utilized as Cabinet has already approved the request to amend the existing Proceeds of Crime Act for amendment by Cabinet Conclusion 603/2022. So what we're doing there, Mr. Speaker, is that we bring to the House what the Cabinet has already agreed, Mr. Speaker. Mr. Speaker, these deficiencies to be highlighted, amendments are sought based on the draft bill from the RSSS. We are asked to amend Part 2, Division 1 to 8, that deals with confiscation. Part 3, Division 1 to 10, that deals with civil recovery. Part 5, Divisions 1, 2, 5, 7, and 8, that relate to investigations. And Part 6, General, Part 7, miscellaneous, Mr. Speaker. Mr. Speaker, the bill amends the Act by changing the definitions for the terms relevant offense and tainted property, and providing new definitions for words such as civil recovery investigation. The Act will also amend in relation to the application of a forfeiture order for confiscation order or on conviction to provide a High Court with the power to make a forfeiture order or confiscation order when a person is convicted of a criminal offense, and to provide for a request for leave. In terms of a confiscation order or conviction, the Director of Public Prosecutions is empowered to serve a written notice on a person convicted of criminal conduct and to determine a question on the balance of probabilities, Mr. Speaker. A very important role for the Director of Public Prosecutions, Mr. Speaker. And that is actually a sacred position, Mr. Speaker. And the power is a constitutional position, and his power now is being strengthened by the passing of the Proceeds of Crime Act, Mr. Speaker. So we always expect that the person in the position of Director of Public Prosecutions is beyond all forms of scrutiny, is impartial is impartial to a point where his impartiality cannot be seen because he is so impartial. Very important, Mr. Speaker. It's very important. The position of Director of Public Prosecutions. Very important job, Mr. Speaker. And every word, every statement made by the Director of Public Prosecutions is a statement that has great relevance and a statement that has a lot of reach. Not reach, Mr. Speaker. And by the actions or by the words, intended or unintended, the Director of Public Prosecutions is a position that is always scrutinized and a position that must be beyond scrutiny, Mr. Speaker. Mr. Speaker, a number of new provisions are proposed for inclusion in the Act to make provision for the time of payment under confiscation order, interest on amount unpaid under confiscation order, and considerations of the High Court after making a confiscation order. Other provisions in the Act allow for the High Court to order payment by a financial institution variation of an order where an amount available to a defendant is inadequate and a discharge of a confiscation order, Mr. Speaker. And Mr. Speaker, you will note that somewhere in the bill, any sum, if you look at section 29R, Mr. Speaker, on page 51, the minimum amount to be seized in an account is $10,000, Mr. Speaker, which is less than 3,000 US. Or is it 3,000? So anytime, Mr. Speaker, that you have $10,000 in an account, it can be seized if you fall under the remit of the Proceeds of Crime Amendment Act, Mr. Speaker. And Mr. Speaker, that is something that is noteworthy. The amount that can put you in problems, Mr. Speaker, if you fall foul of this act, Mr. Speaker. 10,000 Eastern Caribbean dollars, Mr. Speaker. And Mr. Speaker, there is need for clearance for the Attorney General on the matter, because there are some other acts that say 10,000 US dollars, and this one says 10,000 EC dollars. I don't know if the Attorney General can advise on that, Mr. Speaker, because we've passed some bills here that say that the banks